Hi, I'm Greg Dell, and I'm here with attorney Rachel Alters, and we're going to discuss with you principal disability insurance claims. They were formerly known as Principal Financial, and they've, in the branding that all of these insurance companies have been doing, decided to shorten their name to Principal. Anyhow, over the past 20 years, we've handled hundreds of principal long-term disability insurance claims, also waiver of life insurance premium type claims. Now, we're going to discuss today about claim denials from principal, and more specifically about how to handle an appeal of a principal denial. And this goes to if the claim's governed by ERISA versus if the claim isn't governed by ERISA, then you can voluntarily choose to file an appeal, but you don't have to file an appeal. Your opportunity at that point may be to file a lawsuit, but we're going to assume that if you have an employer-provided policy, then you have to file an appeal. And we want to give a few tips in this video as to what are the best things to do to pursue your appeal. Obviously, we think that you should have a lawyer guiding you and helping you throughout this entire process, but we still want to talk about the most important things that we do in this appeal so that you know what lays ahead so you can decide whether or not you want a lawyer or not. So, first steps when a claim is denied is obviously you get a copy of the claim file, which the principal is required to give you.
Right.
When you get the claim file, why is it important to have the claim file as a starting basis, and then what are you looking to do once you get the claim file?
Well, once you get the claim file from the insurance carrier, which they're supposed to provide within 30 days of your written request, the claim file usually is supposed to contain all the medical records, documentation, peer review reports, anything important that the insurance carrier principal reviewed to determine whether or not they believe you're disabled. And if at that point, which they have denied your claim, they should have some sort of physician opinions, which are usually in the form of a peer review report, contained in the claim file, so we can evaluate what their doctor's opinions are and what they base those opinions on. And everything that they reviewed should be contained in that claim file, including some claim notes from the people handling the claim.
Right, so that claim file can be anywhere from 500 pages to 10,000 pages, correct, depending upon if you've been on claim, or if you've been on claim for years, it's going to be huge. If you just recently got denied, it's not going to be as big. If you have 2 doctors or 10 doctors, it's going to decide. But right, you're looking for that needle in the haystack information, which you said is the medical review. Their internal notes are in there, their emails are in there, video surveillance is in there, all kinds of stuff. So once you go through that and you pull out the medical reviews, and you go through all the medical records, what's the next step that you're taking that's important?
Well, after we review the medical records, we have to determine, and the denial letter, because obviously they put the basis of their denial in the denial letter. So we'll review all of that so we can determine how we're going to fight this. And we need to refute what their doctors are saying. So we have to get on board with the claimant's treating physicians to find out, number one, are they supportive of your inability to work? That's the most important part of winning an appeal, is to make sure you have physician support. And if for some reason the claimants don't have physician support, because a lot of physicians don't like to fill out paperwork, some of them, they're there to treat the patient only and they don't want to be involved in any kind of disability claims. If that's the case, then it's, our job is to find them or help them find a doctor who would be willing to fill out that paperwork, who would be supportive, and to make sure that the medical records that are being documented properly so that we can get the appeal overturned.
So let's talk about, because some people say, principal doesn't really do this. Other carriers say, oh, just write a letter to us and tell us why you disagree, which is what you don't want to do. You have to provide additional medical evidence, and it's not an easy process because you have to be able to approach your doctor and basically say, look, I need you to reply to what they said, and you need to know how to get that information out of the doctor, and you need to know what information to get. It's not as simple as just, hey, doc, I need you to reply. So what do? We basically go with what we call custom attending physician statements, where we take into consideration your occupation, the definition of disability, everything that you've already said, all of the information that their doctors have said, all of the whatever video surveillance they may have of you, and then we create a custom document that goes to the doctor to say, can the claimant do all of these particular things which are specific to their occupation or any occupation?
Right.
are the claimant's complaints of A, B, C, D, and E reasonable?
Right.
Yes or no? I mean, we know every single thing that the disability claims person who's evaluating the claim and their doctors are looking for. So we're going to put the claimant in a position where they're giving them every single piece of information, so they can't come back and say, well, you didn't tell us this, or you didn't show us, this particular thing. Now, we can't create an objective finding on an MRI if it's not there, but you may not have certain testing that you now need to go get done that you may not have wanted to, but we know if you get that testing and if it is positive, it's going to make it a lot easier to get your claim approved.
Exactly. Like one big example is the nerve conduction studies. So a lot of times the carrier will deny a benefit because they say, oh, well, maybe there was some sort of positive MRI, but there's no evidence of radiculopathy because there's never been a nerve conduction study. So the first thing we would do is say, hey, to the claimant, go to your orthopedic physician, your neurologist, and see if they would agree on putting you through a nerve conduction study. And if it does show something, nerve damage that's positive, that's something that would benefit their claim if that's, one of their claims is having pain shooting down their leg.
Right. Yeah. And then the other type things we may do, because we have to show restrictions and limitations, is we may request a functional capacity evaluation to have you go through, it's non-invasive type testing, but to have you go through a bunch of different testing that will show how long you can sit, how long you can stand, do you have limitations in walking. There's arguments as to whether or not those tests are reliable, but the bottom line is the insurance companies use them all the time, and so we often like to use them if we can get positive feedback from that that's going to show restrictions and limitations. They're hard for the disability insurance companies to rebut.
Right, and sometimes the doctor won't fill out an attending physician statement from an insurance carrier that asks specific questions as to how long you can sit, stand, squat, bend, how much weight they can lift. Some physicians require an FCE, a functional capacity evaluation, prior to filling that form out. So sometimes it's really helpful to get those tests to provide them to the doctor so that the doctor feels comfortable filling out the attending physician statement.
Right. Now, the other thing with Principal is some of their policies are, and in any disability denial, we got to look at the definition of disability.
Right.
So if you have an own occupation definition, then we have to show that you can't do the duties of your own occupation. If you're in the any occupation stage, then we got to show that you can't do the duties of any occupation. And sometimes it's any occupation which pays you 60% of what you used to earn. So there's so many different definitions. There also could be this national economy standard definition, which means even though you were a director of a company, they're not going to look at how you did your job as a director. They're going to look at how a director functions in the national economy. So if it has a national economy definition disability, and it may not, that's another factor. But important thing when we put together our appeals is we look at how did their vocational person conduct an occupational analysis.
Right.
Did they do a labor market study to see what other jobs are available? Did they properly consider your occupational duties? Are they being realistic about what the occupation is, and are those jobs available?
Right, and do you have the educational background to perform those jobs? Because sometimes they don't get that right either.
So I know when we present occupational evaluations and analysis in an appeal, it's extensive. It's several pages. We go for outside information to make what we think how the job is done in the economy, and then often we'll use a vocational consultant expert that we'll retain who will review all the medical records, interview you, look at all of the occupational duties of what is required of your job, and come up with a expert report to show what the occupation is. So, so now we've done a detailed analysis of obtaining additional medical evidence, plus we're presenting, this occupational evidence, and now, as the attorney, we have to tie it all together as to how that applies to the definition of disability.
Right.
So it's, for me, it's challenging. How do they expect a claimant to really do this on their own, because they're just going to get snowballed by an experienced insurance company that's going to, that's going to look at that information, and if you don't put it together right, then here's the downside. They may look at your medical information that you send and your occupational, but how have you protected yourself in the event that you don't win the appeal and moving forward to a lawsuit?
Right.
And why is that important?
Well, it's really important because when the case ends up in court, all a federal judge will see is what's in that claim file. And most of what's in the claim file is the medical records that were already submitted before the denial, and then whatever's in that appeal. So if your appeal is a one-page letter stating I disagree, and your doctors say they disagree, and then that's all you submit, that's all a judge will see, and they're going to base their opinion on whether they believe that the insurance carrier principal had a reasonable basis to deny your claim. And if you don't have a good opposing argument with good objective proof of your disability and the fact that that disability is preventing you from being able to work in your job or any occupation through whether it's a vocational analysis or an FCE or an IME, or you have another doctor writing a report, all of that is very important when a judge looks at it and says, well, here's the evidence that the insurance carrier has, and then this is what the claimant has, and obviously the scales are going to be tipped in favor of the insurance carrier. So it's very important you get one shot at an appeal. And if that appeal is not done to the best of your ability and you get every possible piece of information into that appeal, once that decision is made, and if the principal does not overturn that claim, then you can't submit anything after that. So somebody can go out of the house, have another diagnosis, get hit by a car, anything can happen after that final decision. The judge will never see that. So it's really important to get everything you can get into the appeal on that one shot that you get.
And then the other thing is that it has to be strategically drafted.
Right.
Because there's a lot of lawyers who will try to do this type of work, who don't do it often, and then they'll start throwing in case law, which is really irrelevant, telling the insurance company you didn't do this, you didn't do that, and as all they're doing is making you have a losing case in the event that you get denied. Because if this case goes to litigation, we have to prove that the disability, that principal acted unreasonably. Right. And if we go ahead and give them a roadmap as to everything that they did wrong, and then they go, thank you, Dell and Schaefer, for giving us this roadmap, now we're going to look at every single thing that you said, and if they fix it, or even at least look at it, what are we going to argue in litigation to say that you acted unreasonably, other than we don't agree with your conclusion? But not agreeing with their conclusion is not acting unreasonably. So this is a very unique world when it comes to submitting an ERISA appeal, and it has to be thought about what happens if we don't win, as opposed to just thinking, I'm going to win just by telling them they were wrong, because that's never going to help you win. So
No.
with these kinds of claims, you and I could talk about ERISA appeals and strategies for hours. The bottom line is that if you have been denied, the process is that you would send us a copy of your denial letter, a copy of your policy. We'll immediately review that denial letter, and just based upon our review of the denial letter, most of the time we can tell you if we think you have a case that we would be able to help you to win. We don't charge you any fees or costs unless we win your case. We don't charge you any fees to review your claim and let you know if we think we can help you. So that's our free initial consultation. Rachel and I have clients all over the country. Our law firm's available to represent you no matter where you live. We welcome you to call us, and we appreciate the opportunity to work with you.